Yeah, we
Go,
want to holler,
boy.
holler.
Lavon, you like that?
Yes, I like that one.
Throw up both your hands. Okay.
Throw up both your hands.
Yeah.
Oh yeah, throw up both your hands.
Oh, okay. You stay muted, Mr. Bailey, please.
Yeah, y'all
don't
can come
shout.
up in the courtroom, but I can't.
Beg your pardon?
Nothing.
Oh, I didn't think so. Okay.
Oh, I ain't think so. I'm just gonna repeat what you said. You said throw up both your hands.
No, I didn't say that, sir. That was not me.
I was about to lift up both my hands. That's all.
All right.
I was about to.
There's John Howler.
Okay,
the
there's
attorney. Is the attorney here?
Yeah, Mr. Howard, your client, and okay.
I don't see him.
What kind of? You must have
You
a
sound like a
small
man.
screen,
You sound like
pal.
a man there.
Oh, there he is. Yeah, John, we're back.
All right, Mr. Holly, you ready?
I'm ready.
All right, Mr. Bailey, I'm calling your case 2405562701, People versus Marvin Bailey.
Good morning, Your Honor. Cal Nazier for the people.
Good morning, Your Honor.
Where's the nitro camera not on?
Oh, yeah,
I don't see him.
Girl, okay.
Hold on, sir.
Yeah.
Mr. Holly, appearance.
John J. Holler on behalf of Mr. Marvin Bailey, who's joined us by the Zoom technology.
All right, Mr. Bailey, I need your name, sir.
Marvin Bailey.
All right, good morning. All right, Mr. Nazier, any offers here?
Judge, Mr. Holler emailed me some information yesterday to give me more to look at and read, and I've had email communication with him. Currently, the offer is no reduced plea.
All right, how you want to proceed today, Mr. Holler?
Well, the offer is no reduced plea and 2 years of probation. Isn't that right, Mr. Najjar?
Correct.
Okay.
With other conditions, that's correct.
Okay, with some other conditions to be determined. If we can do a situation where my client can pay in lieu of community service, something like that, we can take a plea today.
So the offer on the table is 2 years of probation for a felony, which honestly sounds like a reasonable deal. However, he believes he knows the law better than everyone else, despite relying on information picked up from online videos rather than real legal training. Instead of listening to qualified professionals, he's convinced his own version of the law is superior. That mindset usually leads to worse outcomes, not better ones.
His camera's off.
I'm here.
All right, you understand what the prosecutor's offer is, sir?
No, I don't.
Mr. Nazier.
I don't even see the prosecutor. Who is the prosecutor? His camera's not on.
What does that have to do with it, Judge?
The offer that we've discussed is to plead guilty to carrying a concealed weapon without a license to do so, which is a felony. 2 years, a sentence agreement of 2 years of probation, and you will have the opportunity to pay.
Fuck them.
Just because your camera is off doesn't mean your microphone is, and a careless comment can have real consequences. Small slip-ups like that in court can lead to serious trouble, including jail time for direct contempt. It's a reminder that you always have to be careful and respectful when participating in legal proceedings, even online.
Hey.
Okay.
Mr. Bailey, watch your mouth, sir.
Man, okay.
Here's what's gonna happen, Mr. Bailey. If you keep it up, I'm gonna bring you into the courtroom and take you into custody and find you in contempt. Settle down,
All
sir.
right, bro. All right.
That's the judge and not your bro.
All right, sorry about that. Sorry about that, Judge.
All right, go ahead, Mr. Howland.
Okay, thank you, Your Honor. And at the time of sentencing, the court can determine that that Mr. Bailey would be able to pay a certain sum of money in lieu of community service if he so chose. So it would be like an either-or type of thing. So the court would determine an appropriate amount of community service versus an appropriate amount of additional costs or fines, however we want to characterize that he could pay at his election. He would be on probation for 2 years.
All right. Mr. Bailey, you understand what that offer is, sir?
Yes.
All right, you waive your right. Now you understand you have a right to have a preliminary examination, sir?
Yeah.
You waiving your right to have a preliminary examination today?
Yes, sir.
Anybody threaten you or force you to get you to waive your examination right today?
No, don't nobody threaten me.
All right, court's going to accept the waiver. Mr. Bailey will automatically be bound over. Mr. Holler, as it relates to the arraignment, he's standing mute and waives the formal reading of the information.
I do.
Court's going to enter not guilty plea
Hey,
today.
can I ask a question?
The real question here is whether you should be asking questions at all. You already have a competent lawyer on the call with you, so it's usually best to run any questions by them first. They know the process and can guide you on what's appropriate to ask the court, which can save you from unnecessary trouble.
Go ahead, sir.
Can I ask a question?
Go ahead, sir.
After we do this plea, like after I finish my probation and complete everything, like, would I still be able to get my license? Because I like to have my documents intact, in order, and everything.
All right.
I know I was wrong for the case and everything, but like, would I be able to do that?
You have to talk to Mr. Holler about that. He can give you the legal advice.
Okay.
All right, please raise your right hand. You freeze. All right. Do you solemnly swear or affirm the testimony you're about to give today will be the truth?
Yeah.
Yes?
Yes.
Yes.
All right, you can put your hand down. You understand if I accept the plea from you today, sir, you give up or you waive, first of all. You understand that the maximum penalty I can impose if I accept a guilty plea can be up to 5 years in prison.
Yeah.
You understand if I accept the plea from you today, sir, you give up or you waive certain constitutional rights.
Yeah.
You understand you waive your right to have a trial by judge or jury.
Yes, sir.
You have your right to remain silent without that silence being used against you.
Understood.
Is that yes?
Yes, sir.
You have your right to be presumed innocent until proven guilty beyond a reasonable doubt.
I'm gonna say yes to that, but I was already, I'm guilty. Yeah, though. Cause they already said I was guilty, man.
No, that's not how it works. The court can't simply take your guilty plea without you actually admitting what you did on the record. You have to explain exactly what actions were illegal, not just say, "I'm guilty because someone told you to." The admission has to reflect the facts of the case, and the judge needs to hear that to accept the plea.
Sir, what you understand is you're giving up certain rights. You have certain constitutional rights. In order to take a plea, you have to give up or waive those rights. That's what
Yeah, though. Yeah.
Right. You understand that you waive your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yeah.
Is that a yes?
Yes.
Anybody threaten you or force you to get you plead guilty?
No.
Anybody promise you anything beyond what the prosecutors? Anybody promise you anything beyond what the prosecutor's office has offered you to get you to plead guilty?
No.
All right. Anybody, Mr. Nate, Mr. Nature, daytime, location, factual basis, please.
Thank you, Your Honor. Mr. Bailey, on February 5th, 2024, in the area of Binder Street in the city of Detroit.
It's Binder, Binder, Binder.
Binder Street in the city of Detroit. At some point, did you have contact with the police that day? At some point, did you have contact with the police that day?
I ain't had no contact with the police. They contacted me.
Right. Okay. You were arrested that day?
Yeah.
Okay. So prior to that, at some point prior to that, did you have a handgun, a pistol?
You said that I had a handgun, a pistol?
Yeah.
Yeah, I had that big Glocky on me.
And was it concealed in some fashion at some point? In a
I had a
pocket?
30 round hanging out the clip. I had a 30 round hanging out. It wasn't concealed. It was a big 30 round on it. It wasn't concealed. But yeah, though, I had it on me.
Okay. Was it in a pocket or under a shirt or something?
No, it was outside. It was sticking out. It was hanging out.
Okay. Was it partially inside of a pocket?
No.
All right.
I had it out.
Mr. Howler, I don't know if you need to have a discussion, but we need to know whether it was concealed or not at some point.
That's what I'm saying. My shit wasn't concealed. That's what I'm saying. I don't even know why I'm going through this. My shit wasn't concealed. It was not concealed.
All right,
Now
Mr.
let's
Holler.
go if it was concealed. I want to go to trial.
Hold on,
You're
Mr.
what?
Bailey. All right, Mr. Bailey.
My gun wasn't concealed. It wasn't concealed. And I'm sick y'all trying to do me like this.
No one is trying to make things harder for you. In fact, they are doing you a favor by offering a minimal sentence for something that's fairly straightforward for them to prove. Under Michigan law, MCL 750.227, it's a felony for anyone who isn't exempt to carry a concealed firearm. You've made some unclear statements about your gun, saying it was sticking out or hanging out. Even if it wasn't fully hidden, as long as it was partially concealed and not openly displayed on a holster or belt, the law still counts it as concealed. In Michigan, partial concealment is treated the same as full concealment under the statute.
All right, Mr. Bailey, settle down. All right, Mr. Howard.
Man, this is wrong, man. Y'all do
Mr.
people
Bailey,
like this, man.
Mr. Bailey, just listen. I'm not going to accept the plea. I'll let you go forward to have a trial. Mr. Holler, you want the examination date?
Yes, I do.
All right, so Mr. Bailey, you're going to be going on. I'm not going to accept any pleas from you today, sir. If you're innocent, we're going to let you go forward and exercise your constitutional rights to have a trial. So we're going to the next stage. So the next stage is at a preliminary examination. Mr. Najer, as it relates to any offers.
Your Honor, it goes forward as a no reduced plea.
All right. So, Mr. Tooks, can I have examination track from Mr. Bailey?
Not a problem. It's going to be Judge Sabri.
All right. Mr. Holler, this matter is going on the examination track before the Honorable Judge Aaliyah Sabri for a Zoom PCC May 30th at 8:30 a.m. Again, before the Honorable Judge Aaliyah Sabri for a Zoom PCC May 30th, 8:30 a.m.
Okay. All right, thank you.
All right, Mr. Bailey, you going to the next stage, sir. You going forward to have a preliminary examination, sir. You got that date and time?
Yeah, 'cause I ain't going out like that, man. I can't go out
That's
like
fine.
that, man.
That's fine, sir. You can exercise.
I can't go out like that. My shit wasn't concealed, man. They trying to play me dirty.
All right, you can go forward, sir, and have a trial. Have a good day, sir.
All right, everyone. That wraps up the video. Sometimes Judge Sab posts her courtroom trials on YouTube, so there's a chance we might see how this one plays out. My prediction? This individual's misunderstanding of Michigan law could end up causing him real trouble, possibly turning what could have been probation into actual jail time. If you enjoyed the video, hit the like button. If not, hit dislike, but make sure to leave a comment below and subscribe with notifications turned on so you don't miss any of my future content.